Before you see the notice, let the public know that we had a posted
Oh, excuse
discussion.
me, yes. We had our executive session, we discussed personnel issues. No votes were taken, no motions were made. It was strictly discussion. It was only on personnel issues.
You see now, Madam Chair, I'd like to make a motion, one many motion we try to make today. The first motion I'd like to make is for the board to approve the salary for the two deputies of the board election system of Ms. Barbell and Ms. Whitaker, commensurate on August 12, 2013 to be a salary of the current law.
Second.
Object.
August 12th, you said?
Yes, please. August 12, 8, 2014. August 12, 2013. Yes, ma'am. Yes, sir, sorry.
Member Ross?
What is going on that day?
I'm reading some, Mr. Ross, through the chair from the document from the vacant and new position analysis dated and signed by Mr. Kenneth Holman, who is the Director of Personnel. This one we're hearing now.
Mr. Member,
I second the motion.
excuse me, I thought so.
Yeah.
Member Ross?
Well, the reason for my point of information is because I heard Member Williams talk about the acceptance being in October.
Exactly, that's why I asked if it was August.
So,
The reason I use that is the date of assignment first, but if it's a document of acceptance, we can amend. I don't have a problem with it.
Member Moore?
I'm just saying you can't.
To correct the record, please, the appointment letter says that their term, their 8-year term starts October 21st, 2013.
Motion to amend, accept.
So what part did you put in the October 21st?
The acceptance date is mentioned in the memo.
Okay, so you, just point of clarification, because I got to write this, and I'm going to accept it, right? So you remove in that.
You need to have a copy of the motion on the motion form also?
Sure. That's why I'm asking what it's saying. You're saying that, you're moving that they be given an $80,000 salary starting at October 21st? So,
According to the document you just mentioned, yes, ma'am.
are you still saying that?
I'm still second, yes.
Member Ross?
To the chair, that motion, was the original motion 78,000?
No, sir.
That
was discussion.
It was disgusting.
All right, you have the motion written, Member Moore?
I'm sorry, the motion was to pay the two deputies $80,000 start from their start date of October 21st, 2013.
The roll call on the motion?
Mr. Larry Basholta, absent. Mr. Harry Daniels, absent. Ms. Claudette Georges.
Yes.
Ms. Lydia Hendricks.
No.
Ms. Wilma Marsh-Monsanto.
Yes.
Mr. Arturo Watlington, absent. Ms. Alicia Wells.
No.
Ms. Liliana Gallardo.
No.
Mr. Delbert Bryan.
Yeah.
Lisa Harris Moorhead. No. Mr. Roland Molinar.
Yes.
Mr. Rupert Ross.
No.
Mr. Glenn Webster.
Yes.
Mr. Raymond Williams.
No.
We have 5 yeas, 6 nays, 3 absent.
Motion is moved.
Motion. Make a motion.
I was going to.
Member Moorhead has a vote. Member Lisa Harris Moorhead has a motion.
Okay.
Call any of them.
Okay, all right, it's yours. It's not the council, you're trying to tell you which names are yours.
I'm making a motion that the deputies, along with the supervisor, meet within the next 2 weeks discuss the issue of the salaries and report back to the board within 30 days as to the results of that discussion. And that Ms. Fox also during that period give us the board some guidance with respect to what their job specs are and develop some kind of form for evaluation.
Second.
Objection.
Moved by Moorhead, second by Milano. One objection.
Can I put my objection right there, please?
Yes.
I think, according to the code, it is the board, not the supervisor of election or the deputy supervisors, set the salary to these positions.
My motion doesn't.
The motion is
My motion
as
doesn't address them setting salary. I have
It's
for
a
them
salary.
to report back to the board.
That's right.
And let me just state the reason, if I may, for my motion. These three people have to be able to work together.
Yeah.
So I'm hoping that by having a meeting and, having it structured where they will come back then and report to the board and develop some job specs and some criteria for evaluation, that everybody will be more.
Excuse me?
I didn't say anything.
You're going to have to leave, please, if you're going to disturb our meeting. Thank
I
you.
don't know what it's
What do you say, Bingo?
That everybody will be informed and, start off on better foot, if you will.
Motion.
There's a motion on the floor already.
I move the previous question.
All right, call for the vote.
What is the motion, please?
The
Will you say the motion?
motion
Just want to have it restated.
No problem. The motion is that the deputies, along with the supervisor, meet within the next 14 days to discuss salary and what, and job specs. And that within 30 days, Ms. Fox get back to the board with respect to the results of that discussion, give the board a written description of each deputy's responsibilities and a form to evaluate them. So at the point that there is some issue, then the board will have some guidance as to whether people are meeting there. I mean, that was the end of the motion. But again, the reason is that so the board will have more knowledge of what is expected of the deputies as the deputies will, and then we'll be able to assess whether or not they're doing their job.
You have your roll call paper for your motion. Roll call on the motion.
Larry Bishopla, absent. Harry Daniels, absent. Ms. Claudette Porter.
No.
Ms. Lydia Hendricks.
Yes.
Ms. Wilma Marsh Monsanto. Mr. Arturo Watlington, absent. Ms. Felicia Wells.
Yes.
Juliana Bellardo.
Yes.
I'm sorry, Mr. Delbert Brown.
No.
Lisa Harris Moorhead, yes. Mr. Roland Molnar.
Yes.
Mr. Rupert Ross.
Yes.
Mr. Glenn Webster.
No.
Mr. Raymond Williams.
Yes.
7 yeas, 4 nays, 3 absent.
Motion.
Member Williams. Wait, I want to set some dates, probably. Mrs. Fox, you will meet with the deputies. Today is the 14th. Before the 28th of February, and you get back to us on before or by the 14th of March. 30 days.
Motion.
Member Marsh Monsanto.
I move that the salary for the deputies be set at 78,000.
That's all I want.
Because of the motion that was just passed. I ruled that out of order.
Okay, actually, we'll change that out. Motion can be made anytime.
No, that's not the challenge.
The challenge is, what is the challenge?
We already dealt with that line of business.
The salary does not prevent her meeting with these people or vice versa. That is not an intervention of any meeting. It doesn't say that before they meet, during the meeting. We can vote after the first motion is passed, and another motion is completely different.
Who
from any
seconded that
previous
motion?
Aye.
All right.
Objection. That is not a
It's not,
substitute.
because you had the motion that
I
before.
moved the previous question and we haven't dealt with the.
Yes, we did.
Yes, we did.
We voted on this motion.
But that's already passed.
That motion
That
made
didn't-
a second. Completely different.
That motion is not.
It's not in order with
No,
the
it's not.
previous motion and what was discussed in that. Member Ross?
My understanding is that Member Monsanto made a motion, and it was seconded, and you objected to the motion.
Because it was, okay, I'm sorry.
And you said the motion was not accepted.
Right,
It was challenged, your decision
was challenged
by
by,
Member Bryant.
that's right.
Am I correct?
I'm saying Mr.
No.
Williams
Yes.
said it can be made, and then she said it's not a proper motion for he said. That's how it
Okay,
had.
the chair ruled it was not a proper motion, and you challenged it.
Right.
Therefore, we need to
Vote
vote
on the
whether
challenge.
or not we're going to uphold Member Bryant's challenge to the chair or not, before we go forward.
I need more roll call sheet.
You need, we're voting on the challenge to the chair.
You explain it.
Well-
Reason for the road and rule it also.
Member Brian, we just need to,
No, we have to put on record the way it says not domain, the way it's also. You don't know say it's supposed to.
our motion that was previously passed said that we're going to give 2 weeks and then 30 days, and then we're going to have a discussion and decide on the salary.
And I make,
And the motion now is for $78,000
and I
salary.
made it clear that the Bourgeois court said that the board set the
So we're
salary.
voting on
not
the
the
challenge.
meeting.
We will meet after I just said we're gonna meet and after we hear from Ms. Force.
That is why
This supervisor is going to.
Okay, we're voting on the challenge to the
Wait,
chair.
wait.
We're voting on the challenge to the chair.
that is why it's not any different to the motion.
Madam Chair, can we clarify, we're voting on the challenge
To the chair.
Yes, being what? Yes, being what?
Yes, okay, let me see, yes, you agree with Brian.
No, we don't.
No, you don't agree with it.
That means we're voting the chair.
Right.
You will explain that so that everybody can understand.
Yes, you agree that there's a challenge, but the
Yes,
challenge
you
is
agree
right.
with- yes.
I know you're agreeing with the chair.
Okay, got it straight.
Roll call?
Mr. Larry Bashota, absent. Mr. Harry Daniels, I'm sorry, I read him as absent, but he's excused. Ms. Claudette George.
Yes.
Wait a minute.
Point of clarification.
No,
No, no,
Brian, we got a roll call. We are in a roll call.
Yes.
Excuse me.
I'm voting, go ahead.
Come on,
I
son.
need a motion roll call sheet. This is a roll call for president. People present or absent, so if I could just get it. Okay.
Yes, we're gonna go for that. We're gonna go for that.
Sorry about that.
Yes, you're upholding the challenge, no, you're upholding the chair's decision.
Okay, let me start again. Mr. Larry
That's wrong.
Bashota. How is it?
That is wrong,
How is it?
because if you support the chair of the motion that I am challenging, you must vote yes in support of the chair.
No.
All right, go ahead.
Excuse me.
You made a
Yes.
challenge. We're either supporting your challenge
Or
or
you're
I
not.
challenge her ruling. If you support her ruling, then her ruling is not, we don't take this motion. Well, I do know.
Yes, if you support the challenge, no, if you support the chair.
Mr. Larry Bashota, absent. Mr. Harry Daniels, absent. Ms. Claudette George, absent. Ms. Lydia Henderson. Ms. Wilma Marshman, absent.
Yes.
Mr. Arturo Watlington, absent. Ms. Alicia Wells.
No.
Ms. Liliana Gallardo Del Rio.
No.
Mr. Adelbert Bryant.
No.
No, he voted already. Ms. Harris Moorhead, no. Mr. Roland Molinar. Mr. Molinar.
Yes, I'm in support of the challenge.
Mr. Rupert Ross.
No.
Mr. Glenn Webster.
Yes, I will support that challenge.
Mr. Raymond Williams. 7 noes, 4 yeas.
Challenge is lost.
Challenge failed.
Wait a minute.
Rick?
Anybody have a rush rule here?
Yes.
I have,
Motion, Madam Chair.
Motion,
Clarified how we were voting and you voted against yourself.
I vote against myself.
Member Williams has the floor.
Motion to reorder the agenda, and I'm asking you to pay attention so you can see what I'm proposing. My proposal is to remove item E on finished business.
1 second.
Okay.
Okay.
Remove item E2 in its entirety and make what is now item E1 F3. That's the first change. Next change, under new business, section F, make item 6, number 1, number 7, number 2. And I already said to make, what was E1 F3?
Yes.
Okay. And then what is F4 will stay the same. And we'll move through. And the last two items, number 1, number 2, and number 3 will now become in cascading order, 9, 10, and 11. So move.
Member, go ahead, you have that. Or Member Williams could write it for you.
Yeah.
I don't have all that, because I told you I was no secretary.
Okay,
You help them, thank you.
Okay.
It's been moved and second for the various changes to the order of the agenda.
Okay. Everybody good?
Vote on the motion for reordering the agenda. Roll call.
Yeah.
This one is closed to the meeting. No objection? No, then it's so moved. All right, so now we're down to the
New business.
E.
F. We started at the 2014 election calendar.
E1 is down to F3.
Right. To his house.
Where Mrs. Fox is passing out copies of the calendar, please make sure everybody has one around the table. She's had a chance to take a chance to look through it. Number 2 is number 7.
I don't, you know, I did it. I did it all over it.
Excellent.
That's as far as I get.
And F4 stays.
The 4 stays the same. Then we move on to 1, 2, 3.
Okay, the calendar. Member Ross. And member,
Madam Chair, yes.
and member Moore. Member Moore, I'm calling you because this has to go to the persons who pay you. And you and member Ross worked with Ms. Fox on the calendar.
Can I make a comment on that? They should have voted on these changes by February 2nd.
Oh,
Mm-hmm.
and so now that it didn't on that, that was a
mean,
Sunday.
Regardless, it would have to be before the 2nd for to meet the 6-month requirement prior to an election. You have a primary election in August.
So now what do we need to do?
I don't know that there's anything we could do because we've advised them of that. They may decide to vote as they do often. We'll discuss what that means, but they sometimes have a vote notwithstanding any other law to the contrary, which is bad. It's actually, I think, bad practice because that means somebody would have to read the whole code just to know that other laws to the contrary might be there. But the legislature is not supposed to make any changes to election laws, anything short of 6 months prior to an election. So they didn't have to do it on the 2nd, they had to do it before the 2nd. I mean, if the 2nd had been a Friday, they could have done it on the 2nd. So, I have a concern about that. I don't know what we can do other than write a chair. Ms. Wells could write a letter saying there's some urgency here. We're concerned that you didn't do it within the time frame and let them decide how they're going to do it because they're the legislature.
Member Williams?
I think the one specific thing that stands out on the calendar that now poses a severe challenge to the supervisor is the issue of casting a lot of lots and the last day to draw. I would recommend that we ask our legal counsel to opine on that specifically, because I can see where the challenges will become a major issue. If 1, 2, 3 people are candidates were to cast lots, somebody dropped out after the fact, and I as a candidate went out to my printers, to the media, to purchase my paraphernalia, and then the supervisor sends me a letter telling me that I'm no longer number 3, but I'm now number 1.
As we had in.
Right, as I started previously. And then the problem that poses is that I will challenge, if I were a candidate, I would challenge the election system, because I already spent $40,000 in campaign paraphernalia, and now you tell me I gotta change it back. Or I probably was already advertising to the community my number, I've sent documentation to absentee voters. You know, it's and I bring this up because it's not new to anyone at this table. You know, we've had this discussion before, and one of our astute members continued to push this thing forward. This was a conversation before the legislature when the both chairmen of districts appeared along with the supervisor. And yesterday, it was not addressed. Now, it squarely lies in the hands of the supervisor. So I suggest that we get legal counsel's opinion as to how we should proceed with it. Because based on what Member Moorhead has stated, the fact that the period, the 6-month window, has closed, how do they legislate or how do they amend the code to correct that? That's a concern.
Unofficial discussion, it is a major concern. Unofficial discussion that I had, I think with Attorney Salisbury or some other attorney, there was a suggestion of a noon, changing some one of the issues to noon on that day, and then have the drawing of the lots later on that afternoon. But I still will contact Attorney Salisbury probably sometime this afternoon to speak to that, because that's very important we get this taken care of, postings, as you like to say. Member Moore?
This is admittedly a little off topic, but the other concern that's major to me that has not been addressed by the legislature and that we requested, given that we have new machines, and despite the fact that I think Member Molinar and who has been working with him primarily have the machines displayed in a number of places, I anticipate that there will be some anxiety attached to using new machines by some voters, because just by the fact that it's new. Hopefully there won't be many problems, but in states where these machines have been used, there are usually laws that say how many times somebody can vote before
That's on
being spoiled.
Is that coming up someplace on the agenda?
Yeah, well, no, we asked, I mean, I think it's been passed, because that's really election reform. I bring it up only because we're discussing what we may need to address with the Senate. My concern with that is, it makes no difference to me how many times somebody can vote. If the Senate wanted to say 10 times or 20 times, I mean, I think that would be a little outrageous, but that's in their purview. What we need to know as a board is how much paper that we order. You know, how many ballots we need at the polls. And I mean, that's not something we can wait for the last minute to know. So that is another concern that I think we should address. When and if we do address the calendar. The changes in the calendar that should be made.
Any other question or concern or have you brought up about the calendar?
I'm sorry, have the members had an opportunity to review this, to know?
So many of them, yeah, all of them, since October.
Okay, no, I just want to
You just change the format and you get information. That's amazing.
Madam Chair.
Member Ross?
Someone's going to address Supervisor.
Yes.
On first page during the month of May, May 18th has been used as the deadline for withdrawal of nominated candidates. is that. That's what VIC 413 says as we speak. I thought that was a conflicting activity.
The last draft that we got.
That was the draft that you got on the signatures of leaders.
There ain't no signatures here. That's the draft we had on the computer from the December meeting. That's where you put out the rules.
So you're concerned about those dates, Member Ross?
13th and 18th.
Yeah, because
Oh, because I believe, except for that line, I believe the law as currently written places that activity after the casting of lots. And this document comes before the casting of lots. So I think that date, the 18th is an error. The date may or should have been, and I don't have the calendar.
We'll look at the draft.
May or should have been the 28th, which created the problem. This does not create the problem. This resolves the problem.
Yes.
But I'm not too sure that
it meets the code.
it meets the current requirement of the law.
So this Forbes would
We'll look at the
work.
draft one that we have back in the office.
Okay. You can make a note next to that.
Because if this is consistent, if this is what the law is requiring, then this calendar is okay. But my recollection is that the deadline for withdrawal of nominated candidates was after the casting of lots. And that number, rather than being the 18th of May, should have been the 28th of May. And which creates the problem when the legislature seeks to address. Other than that, I don't have a problem with the calendar.
And the 18th is a Sunday, and the 20th is a Wednesday, and probably that's just a typo. Mrs. Forbes will check.
But the one that they have, the next one, the 23rd, the Friday, the deadline for filing substitute nomination, that one, as the note said, that one should be the 28th. That was the note that we got from the last draft, but like I said, we'll go back and check it. So that's where we put those notes in the base and the code and the draft.
Any other comment about the
My other comment is this document is time sensitive.
Yes, correct.
We need to let the community know the election calendar is yesterday, so that they can try to call it. I don't know how the chair intends to address that.
Suggestions? Because this is way late now.
Well,
Member Brian?
suggestion, Member Brian.
That really made it clear last meeting. I wasn't signing anything that is inconsistent with the statute, so I don't know if any other chairperson or vice chairperson will sign it, but Brian is signing anything that is incorrect with the statute.
We should never sign it.
It was mentioned that that's what it used to be, and I won't hear all the time what it used to be, so I ain't saying it.
My recommendation, since this is time sensitive, that the board meet in special, the joint board meeting special session at video conference next week to address this, to approve this specific item.
Okay, suggestion taken.
Which, and nothing else before on the agenda, which means that we meet for less than half an hour.
There's a motion?
Next
Second.
Wednesday.
Objection.
Objection.
I have a question. It is the legislature to change the statute, correct?
I don't think we will change the statute.
Well, this is not in compliance with the statute, correct? That's what you're saying?
That's
One
what
and
we
one.
that's what we want to clarify.
The 18th or the
So if it is
28th.
clear to us it is not in compliance with the statute.
It's not, that's what we're trying to clarify.
Well, I think it's clear to me that's not I saying it's saying, but I'm saying, if you will meet again with the legal counsel to tell us something that I think is clear to me that we already discussed it earlier, district board meeting. And if we don't still call on me to have attorney staff, bring in attorney to come to tell us in time, somebody needs to talk to the legislature president to correct the statute to allow us to do it.
I didn't hear anybody ask for attorney-client.
I didn't even.
Well, I thought you that's the one that's usually here. I didn't ask for
No,
any.
but we didn't, the motion was not to have any attorney deal with this, it was just to check
On the date.
on the date, the
18th
one date.
when
And you have the right.
Question that, right, so we don't need an attorney to opine on this, because they're not gonna know this any better than the board is gonna know.
Well, that's why I'm saying, in addition to meeting again, for something I already know, are we going to have the legislature notified so we can come in compliance or change the date? Which one do you want to do?
The legislature has to be notified of several things, if I may. The things that I spoke about, what we're proposing as the calendar, so they can, because there are statutes that have to change as, you know, in order for us to change these dates. So that's part of what they have to change. But the other, well, it's too late unless they take some action that's somewhat outside, outside of what the statute says, and that's their purpose. I can't speak to that. But the other thing that we need to address with the legislature is the fact that the primary, as of 2010, is supposed to be handled by the parties, and at this point, this board only has a proposal from the Republican Party. Remember well, because this will be something you have to address to the legislature. The parties are supposed to be handling their primary.
Exactly.
We have only received, and we received it back in 2010, the proposal from the Republican Party as to how they would handle the selection of their candidates. No other party has given us anything that we have to approve at this point. There's been some rumors that as I think the former board members know, it was put off from 2012 election to 2014, but there's been misinformation about within the Democratic Party that it's not effective this year, and they have yet to send us anything. So if the legislature is going to put the onus on the board to run the primary again, then we need to know that as well in order to be prepared to do it, because what will happen is we'll be stuck with, the problem that, time and everything else will cause with us not knowing what the legislature is doing with respect to those issues. So I guess my suggestion with respect to that is that we write a letter to the legislature and perhaps the executive committee meet with the legislature majority or whoever to try to impress upon them the urgency of some of these matters.
All right, please.
Listen. Senator Bryan?
If this is elected board, the original law said that each political party is responsible for the cost of conducting the party's nominating officers and candidates. Let the legislature do what they want to do. We already had Mrs. Fox write them and tell them what the law said. She corrected the communication. We went to the one said, the one some guy who was last said. Until the last said, I know to worry about. Mrs. Fox wrote a letter on behalf of the joint board. Mr. Watson said nobody had a letter to do. She read it over, reminding them that the district board and asked, and she's telling them or reminding them that the last said they must do it. So when we meet, I meet the legislature to ask them again. They passed that already. So that's what the law we followed. And that's when the Attorney General writing opinion here, right when the law said. So we asked the Attorney General if we have any obligation to keep the election. Maybe somebody needs to ask the Attorney General if we must keep a primary since the law said that they must pay for it.
They're clear on the license.
Well, that's what I'm saying.
It's,
And first of all, y'all are misconstruing. I said there were a number of issues we need to talk to the legislature about. The rumor is that they're going to change that. And if they do change it, the onus will be back on the board, and you need to be aware of it. Yeah, well, the rumor is that the Democratic Party is going to, have their folks vote against it.
Well, that's what it should be.
Whatever, but
This-
we need to know in some time frame. I mean, you can sit here all day and say it's the legislature's issue and we.
No, it's not the legislature issue.
No, I'm saying, you're saying the law is clear. I agree with you, the law is clear. I agree that the parties should be responsible as the law says, whatever. They have not challenged it again as they did prior to the last election. The judge threw it out saying it was premature because it had already been put off to 2014. But my concern is not what the legislature does, who knows what or doesn't know what. My concern is what our responsibilities will be and us being prepared for them. So I don't want to sit around and wait to see what somebody's going to do without taking some kind of action to figure out what we are going to have to do based on what they may or may not do. I mean, we need to know their true intentions.
Say what you're saying, please. Through the chair, with absence facts, anybody from the Democratic Party tell you when you submit the intention that the Republican Party did already? Have you received anything on that?
No, we haven't. We give them a suspense date, I think, the 14th.
February.
What today? Did you receive anything?
I'm up here, so I'll see what I get.
But if they respond when the court team, maybe you need to ask the attorney to ask what we going to do. But if the last person was supposed to go, rumor, truth, or the other way, I prefer to do what the last one was supposed to do. The law changed, and therefore the notwithstanding the law to the contrary when it's a deadline class, I think somebody or some of us is saying they're going to be challenged. So if we will sit down to wait until they do what they believe they should do to make us pay for it, then we need to let the legislature know if you want to do that, find some money to conduct the primary. We don't have no money in the budget for no primary. They know that today they're invested in that. So if they respond, the Republican Party is running their stuff already. The last
The same letter, that was last time.
and the same letter that was Member Moorhead
We went to our
making,
true party.
the same letter that Mrs. Moorhead making reference to, right? You said the court said it was premature
Before.
before.
And
The
it's
challenge,
this year.
the challenge
The
was.
challenge was premature, meaning that the law is still in place, and the law changed since then. So if we want to wait until they're done that, hope when they change the law, somebody can convince them if they don't change it, to ask to keep the primary, they will find the money to do that. And that's what I'm saying, they do that. The budget that they approved, knowing that that's what some of their intention was, to not keep a primary, it is straight to me that that's what we're supposed to do. Preparing to get from them if they're going to respond. So, when they're going to meet,
There's a meeting member, Moorhead scheduled, the executive scheduled for next week in,
I have no idea, but, and sometime this afternoon, sometimes they put out 2-week schedules now. I have been out of work for a couple of weeks, so I don't know.
today and yesterday they were closed. I mean, no meetings, no hearings. just
Right, but
in the
what I'm saying is that you should be able to find out from the legislature if there's something scheduled. I don't know, I'm out of work until I come back on my Thursday.
So we need to get to Monday, which is a holiday, to know if they've responded to your deadline of today. This is, that's Tuesday will be.
But we know the answer.
Okay, but we'll wait from then.
you know the answer is that?
So there will be a delay, but I'm just saying, we haven't gotten anything yet.
Well, I don't think we should wait another.
No, that's
Either party or the legislature or the board together. If the last time is supposed to be for the last time, and I remember when that amendment was offered and voted on it, it was before the 30th legislature. And some of them bended down now. So in those last week, dollar bended. And it was premature, it means they had known before the time to keep it enforced. So if we want to continue dangling and measuring, I ain't getting part of it.
Any other concern about the calendar? We know that we need to write the letter, like Member Moorhead suggested, to let them know the time is.
Yeah, but I think most importantly though, even that portion of the conversation, the recommendations that Member made, if it's clear. But yet again, we need to, based on what Member Ross suggested to meet to finalize because we're holding people, we're in February, and we're holding candidates hostage without this kind of date finalized.
Well,
And if I may add,
logistics.
even if the law is skewed, for the lack of a better term, one act should follow, the casting of ballot should follow the withdrawal of nomination by law is reversed. Even if it is, we have to pass the calendar as the law says. So once we determine that it is what it is. We don't break laws. So we make calendars based on law.
So how is the law skewed then?
Because I'm trying to find it, but
You know,
the law basically says you cast lots and then the person can withdraw after that. And it should be you withdraw and then cast the lots.
But that was something that been going on for years.
Because
And when it was recommended for them to change it, they didn't touch it.
I'm not disputing that. I'm just basically saying that this calendar we have here doesn't reflect that. And we just meet, whatever the law says is what the law is. So let's have the calendar reflect what the law says and adapt it.
Who prepared it? The board?
We did based on law.
Right. If you prepare it based on law,
Well,
it's
the supervisor says the document that she worked from said 18. You know, it could be a typo. I don't know.
you're not typo. You're not a typo.
I didn't type it, so I don't
Go
know.
back and check it.
Well, I'm suggesting, again, that was my motion, I'm suggesting that we check the law, make the adjustment, that we meet by video conferencing at 3 o'clock.
You have a phone right there, right?
It's not in the code, it was,
You said the law.
it was Act 40, Bill 30-0272 that was passed on October 21st.
And it's an act now.
Yes,
It is the law. It is the law as we know.
It is the law, yes.
And if Mrs. Fox comply with the law as
Correct.
written,
Correct.
and write this by a group of people here, then somebody came following what the law said right
No,
there.
no, no.
If it was the past practice that was mentioned the last time.
Member Brian.
No, but you say you didn't say you were arguing. But can I finish what I'm saying? The last time we discussed this, let me tell you what I'm saying. The last time we discussed this was the district meeting. And Mr. Washington asked that they asked at the joint board meeting that both chairpersons sign off on this before we come to the board. I tell you, it is conflicted and I am saying because it's contradicted what used to I understand the law. And then they said, well, the custom to do it. And I said, because the past practice, that don't mean I don't go along with it. That was my statement, correct?
but you're mixing it up.
I'm not mixing.
No,
But let's go ahead, I go.
All I'm asking, and I'm the one that raised it. I was on the committee that was charged with working to put this draft together based on law.
And I didn't discuss it.
And I'm looking at the document and I see that from my understanding of the law, line 4 is not correct. So I'm asking supervisor, and me myself also, free of this atmosphere, to correct the document, make it consistent with law, and then this House meet and adopt it. That's all.
Correct this document.
That's my motion.
I'm saying,
And then we done that.
no.
That's why I just move on.
Yeah.
Who are we at this bill? I was going to go on Russian game. I ain't flying up to him. This
Is a motion?
Mr. Ross is saying, Mr. Ross is saying you want to meet and adjust this to comply with the law. That what you just said?
Correct.
Okay. And then you're asking again, is the law going to be changed from what it is? Say to do this. So which one?
No, it's not correct.
Well, this is wrong already, right? Is this correct as it
No,
stands?
One thing is a typo.
Is this correct as it stands? What is the 1 or 5 or 5 is something wrong with this document and
There's
this?
something wrong with the
All
law.
right.
Okay?
and it's the wrongest, it's in contradiction to the statute. Tracing the any weekday church. I'm saying, someone thing in here is in conflict with the law that he has in front of him, correct? No or yes?
We're saying that we believe the document that was submitted to Ms. Fox had correct pursuant to the law.
So who gave it to Ms. Fox?
We want to, the committee gave it to Ms. Fox. We are trying to determine if it was just a typo. What we're saying beyond that is if it's a typo, we want to correct the typo and then adopt the calendar. Regardless of whether it's a typo or not, the law itself needs to be changed. That has nothing to do with this though. We have to adopt the calendar, whether the laws are correct or not, based on the present law. This is just, we believe, a typo. That's all we're asking.
So you're saying that you don't think there's nothing wrong in here except that I believe it's a typo. That's what you're saying.
That's one thing, yes, I know.
Well, then hold on and take the find out if this is a typo. I can put it sometime.
We have to see the original document to know.
There's a motion that was
Again, it's not in this book, Member Brian. The law was just passed last October.
Last October,
The bill was before the legislature October 21st.
October 21st. Last year. Are you telling me that you just have I know today that something got a typo as opposed to an error?
No.
Okay.
This document wasn't before us in October. The law was passed in October.
The requirements to prepare the document was there at the time. And you had committees
And we
to do it.
Member Brown, we prepared it in December at the last joint board meeting, where the subcommittee assigned by the board, right? It is my position that what we prepared was consistent with the law. The document that has been presented to the board for us to adopt has an error in it. It could be a typo or whatever the case may be. We need to have it corrected so that we can pass a corrected document.
Whatever you want. I know
Member
what I'm saying.
Molinar, excuse me, Member
Chair
Molinar.
to Member Ross. This document here, a typo, what might be a typo now? In this, okay.
That's all.
All right.
So there's a motion to have Ms. Fox review and see if there is a typo on that line from the 18th to the 28th, and then the same motion says that we should meet this joint board probably by video conference, teleconference, to approve it. I'm looking at the 18th of February, which is next Tuesday, because Mondays are holiday. Can you check by then?
Your BAT? We've got to get BIT. You're not going to be able to find out in a few hours whether they're.
Couldn't check with them today.
That's right, but.
Then, let's look at the 19th, then, the 25th.
District meeting is closing, right?
No, the 19th is a Wednesday.
I have a question.
So just a minute, so you'll check with BIT to see if we get it, and then we as a joint board should be trying to meet up the 19th. For video conference.
Once the suggestion, once the Fox determines the location, then she can give us date. Because, I mean, we can say the 19th and we can, but, as soon as she can secure a location, she'll let us all know. It's video conference and we only have to get in our cars and go.
Okay. So Ms. Fox is going to make, Ms. Fox is going to make arrangement for the video conferencing, and by then we'll have line 4 corrected to know if it's a typo or not, and then we'll make our vote. Okay, no, probably Tuesday, because Monday's a holiday. All right.
Which is well.
Let's remember.
If Ms. Fox is going to go over this document, and she determined it is not a typo, what is the next action?
We're going to meet as a board and approve it.
Not me. Approve something when she tell her that it's not a typo. That's what you said?
Well, or we're going to change it
Change what?
to whatever was discussed on December 12th. We have to vote on it either way. But we already know that this will be not voted on.
Huh? I already said I'm not
Yes.
signing,
Yes,
as
sir.
was suggested from Mr. Waddington, that the act that each district chair sign off on this.
The only signatory line is for the supervisor of election.
Which I in the front, no, I'm saying, is the board prepare this?
We're talking about,
I thought it was this document.
I am.
well, we
And
had
that's what Mr. Waddington told me.
Carabola, where we decided
She signed
two
with that,
chairs,
she prepared it.
one person, Thomas and yourself.
So probably you have a,
No, the issue is we do a cover letter, the calendar is signed by the supervisor, so I have to sign the calendar. So we're gonna do a memorandum that the board, the chair, the two chairs and the joint agree to disagree. But it's still, I have to sign the
That
calendar.
was
That's what
voted
it's-
on by the joint board.
that's the-
well, your vice chair could always.
The only person that signs it
This
is
is
the
supervisor,
supervisor.
yeah.
You're only asking that chair to sign a letter, which has nothing to do
But why is the board approving what she did?
No, the committee, the joint chair appointed a
I
committee.
hear that, but I'm saying, if it is not required by law that the board sign off on, you know, leave it alone.
Because the law requires the board to approve the guide.
That's why I'm trying to get that
But it
understand.
is transmitted to the public over
And transmitted to the board, when the board is required to do what?
To the public.
To do what?
Over her signature.
Are we want the board to get involved in the fund?
Because it's our responsibility to approve it.
This is it. If you will be responsible for proving what her work is, why you want to approve
We're not
something that ain't
approving
right?
her work, she's only
We
signing
need to
it.
move on.
We developed this document, not Ms. Fox. All she did was reform it.
And you
When we
sign
said
it, that
might
we
have
approve it,
Excuse me?
and you want the board to sign it and approve. You don't approve it?
We have to vote on it, we don't.
Voting on it means doing, what does that mean, voting on it
It means
mean?
approve it. You're not
This is what I'm
signing
saying.
it. You're saying two different things.
No, I'm not saying.
Excuse me, excuse me, excuse me.
But why?
Excuse me, we need to move on. Ms. Fox is going to get back to us, and then we'll be able to figure out what is it we're doing. Ms. Fox's signature is going to be on there. I understand, Member Brian, you're not signing anything, and you said that. We need to move on.
You understand what I'm saying? I'm saying, if you're saying that the board is
I understand.
responsible for approving, when you're voting or signing, you're approving something that your conscience tells is right or wrong.
Which is why we want to make sure it's correct.
Well,
That's
why,
the point.
The next agenda item,
Typo.
thank you, Member Brian. Oh, we did. Item number 7.
What's one seven?
We made it number, it's number 2
You
because
got
it's
that,
74. The only thing I heard was that, I heard something on the radio about that not passing, if money wasn't approved. What's the update on, the monies for the attorney? That's the last thing we heard.
Which one are we talking about?
What's the update? I'm sorry.
Attorney General.
I'm sorry, legal opinion, dated January 30th.
Point of information. Was that the document given to us?
No, that was about the.
It was a legal opinion that talked about us being able to hire a person.
Oh, that's
Right,
what
and
we're
also other
talking
issues.
about. Thank you.
So it was what?
It was, the legal opinion was three issues. One of them was the questionnaire, one of them was our ability, that board's ability to hire anyone other than the deputies and the supervisor, and I forget what the third one was. So that's what that
Okay.
opinion was.
So the pictures on the back.
Right.
The questionnaire, the pictures on the ballot, and us hiring anybody except.
That was the opinion.
Who has a copy? The,
Everybody.
Ms. Barbell or Ms. Whitaker, you have a copy of that
Will
opinion?
be held the last district board meeting.
I'm still asking them if they have a copy right now, in other words, give them the last thing. I'd like to see a copy, please. Did you have it right there?
The question was whether the machines meet the original score of the electronic voting machine. The other one was whether the board can adopt a questionnaire. The other one was whether the board can hire an individual other than just 3 people, or in this instance, an administrative assistant under Title 18, 4 and 41 and all that.
Mr. Brian, Member Brian is correct. No, it wasn't, the picture thing was not on there, everything else we said was on there.
Sequence in the
Now,
picture.
the questionnaire that was submitted at,
Yeah.
at our retreat. It was,
My question, my question is what's an agenda item? Is there an action that needs to be
that's
taken?
what I want to know, why we have to
Take an
this also
action.
coming.
Who?
Because I didn't put this in. And what about the pictured,
The
same thing on
mentioned,
Can I speak for it?
just a minute, Member Williams is waiting for me. Member Williams?
no, I
About the
said,
picture.
What action?
yeah, my question is what action needed to be
Exactly.
taken?
Well,
What is on the
Can
agenda?
I speak on it since
Go ahead.
I read it and I gave it out to everybody to
I read it about.
open it up. I don't know if the attorney general just come out as number, because that picture has been in the law in 2002. And it says the supervisor of the election shall place a picture next to the candidate name and number. In all the years it was absent, it was an issue of sign and cast. The supervisor never placed it from 2002 to now. He raised the issue in a section of the code stating that they should have a photo of each candidate on the ballot. I don't know if they just wake up and they bring the way up. The board didn't consider. The supervisor of election did it and didn't do it. So we now must either ask the supervisor of election to ask the legislature, they're going to provide the funding to fund the manufacturer, they're willing to put a picture on the ballot for the upcoming primary or general election. If they're not going to fund it, and you can still vote it, my suggestion would be then, if Mr. Fraser have an issue about the title of the picture, what the supervising election can or may do, to make a big banner and put all the faces of the candidate in each category at a polling place or in the office, so everybody, when they come to vote and election day, they can look at the picture and see a number and a name of it, because the picture will not be able to be seen neither on the subtract machine that they didn't, and the reason Mr. Aaron said that, neither on the DS200 or the Atomark. So we have to consider the cost, the availability of the photos to put there. Now you have to prepare 2 sets of photos after the primary, because you have to remove those names who lost in the primary in those categories and make another set of banner with the picture and the number of the individuals on it. Now, if it's a cost, if they want to pay for it, fine. But the issue he raised again is that the law requires a machine or a voting machine where the ballot has a button to push to select the candidate by name, by number. I don't think whoever wrote the opinion from Mr. Fraser realized that the Atomark machine has a number and a ballot next to the name of the category and a select button on the machine to select the candidate that you're voting for, and the paper ballot that you use to insert in the DS200 also have a space to mark and also have a number. So I don't know what they're looking for with a machine to push a button to the person, because the Atomark basically can really do it. So I don't know if they examine that machine to know the candidate.
I don't know.
But that's just,
Yeah, but
That's right.
the Atomark is not restricted to the AD people.
I understand, I'm not disputing, I'm not disputing.
Yeah, and the DS200, the ballot, is in compliance with the paper ballot that built before the machine came in, because Senator White, before the 29th legislature, they changed the law to say that a paper ballot is an instrument that the voter used to select the candidate of his choice. That paper ballot was there all the time, and that's what we use it provisional and paper ballot and ballot to send away, because you don't take up a machine and send it away in the army, the navy, or offshore. So the paper ballot is the same paper ballot that you're voting on put the DS200 where you see the screen and so you can candidate.
Before I recognize member Moore, and I remember a ballot, everybody of you were probably there, that we prepared that had the pictures on there, because we know that law was there. You couldn't tell who was who because it stretched the person so much across the little space that we had, it didn't make any sense. So the board at that time decided we're not going to put this picture on it because it was causing more harm than good. Putting the picture on the ballot. Lisa?
Yeah, I just want to, remember Robin is partially correct, but what the actual language of the AG says is not that this machine doesn't have a button, but the specific language that they're suggesting we ask the legislature to delete is to press the button or buttons opposite the party emblem or candidate of the elector's choice, as described in Title 18, 584. We're just suggesting that we ask them to delete that language and remove the requirement for a photograph. And there was a suggestion made in the previous board, I don't think the last election, but the previous one, we talked the same thing about putting pictures at each polling place.
So people see it.
And that, I mean, so that's something we could have them change. If they still want a picture requirement, then they change it to having pictures available at the polling place.
Move it out again.
Or remove it all together.
That's another layer of complication.
Yeah, it could be one letter. But I mean, one letter could comprise all of the stuff, and if you attach the AG's opinion, then, you know,
We're fighting on that.
So what's the action?
Huh?
What's the recommendation?
The recommendation, if I may, is to ask the legislature to strike that section that we made reference to, and to ask them if they're willing to finance it, then speak to the company manufacturer for ESNS to see if they can do it, and always going to look for the sample, because we,
So you give them a choice in essence.
yeah,
Why don't we just agree to strike it here?
well, that's a decision of us to make.
Motion, Madam Chair.
Motion, member Williams.
I move that we, through the supervisor, to craft a letter to the Senate President and copies to all its members in the 38th legislature to remove that specific section. Give it a section, please.
Photograph of 490 something.
Section,
492.
section, Title 18, we are code section, subsections 492B. So move.
Is there any objection?
No, but
No.
I don't know that. That's, yeah, and delete the language that's in there. Well, perhaps what we should do is to ask the legislature to, based on the AG's opinion, do what the AG is suggesting instead of trying to make up our own language. And I mean, I think that may make it clear because they say more than just what was said, and that's why I was going to try to make an amendment. But you know, perhaps what we should do is, in the same letter we're talking about, address this issue attached to the Attorney General's opinion, and ask them to follow that the language in that section. Page whatever.
Okay, I withdraw. Withdraw the second. And I want to clarify the motion. To direct this supervisor to prepare correspondence to the Senate President based on the recommendation of the Attorney General. Letter dated January 30, 2014, specifically page 6, paragraph 2. So moved.
Second. Any objection? Hearing none. So, we have
And I think, you finished? Another question that was answered from the Attorney General's response to Mrs. Fox was that I think we have already resolved that matter already in the St. Croix district. Because we already had interviews for the position of administrative assistant. We have a finance election in 24th of this month. And that would be a new issue, a question that so we already have to deal with Mrs. Fox, have the communication. So basically only one issue remains as it relates to the questionnaire, and I am not sure what all the questioning that was before the board, because I was not at that board meeting, except that at the appropriate time, I would like to make a motion to address the concern about the questioning.
Member Gordon and the
I was gonna make a motion with respect to that. My motion is that the committee that was working on the questionnaire review the AG's opinion and revise the questionnaire pursuant to what the AG is saying is acceptable or not.
What did you say?
In the AG's opinion, they're saying what can or cannot be included in the question. Well, not specifically what can or cannot be included, but they delineate what the laws are in terms of the qualifications for an elector. So they're saying that you cannot go outside of those parameters, what the law dictates that you can ask of, that these qualifications require. So, I mean, if a qualification is that you lived in the Virgin Islands for the last 3 years, depending on the office, then you can ask, have you, for a senator or whichever it applies to, have you lived in the Virgin Islands? So I'm just saying that since there was a committee and they worked on the questionnaire, I think they should have the opportunity to revamp the questionnaire by taking into consideration what the Attorney General has said.
There was a second?
Our concern, I need to have a discussion on that.
Your second to the motion.
I have a concern, I want to share with the members, I'm not saying concern of this moment. I don't know if anybody recalls this election system evolutions qualification for officers. It's a paper like this. Right? You see this paper here? Right? Now, if you look at this thing in compliance with what the Attorney General is saying, this is what needs to and must be changed. Because right here, it says 1 to 5. Be a qualified voter. Right, the next one says 1, 4, and 5. No convicted felon who has not been pardoned. This is inconsistent with the Attorney General's own letter. So all we should do now is adapt and change this and put what he said. So what we have here today to offer, if you want to look at it, is that the same form we changed. If you look at it, somebody have them, where it says 8, 1, 4, and 5, no convicted felon or or a crime involving moral turpitude pursuant to VIC revised Organic 1954, section 6A and B. That's what he said about it. So if we want to correct and follow what he said, that's what we should be doing with the same form that we need to be compliant. And at the same time, this is where the board election right now. It says election system versions, candidate information sheet. You have the candidate name, sheet to do that, the office you're looking for, the party, physical address, mailing address, telephone number, email, contact person, and what needs to put in now, candidates are required to attach a copy of the police report consistent with the revised agenda. That's what should be addressed. There's a simple solution to the same back and forth confusion. So I move that we adopt this replacement of this incorrect. The Attorney General is telling us right now, this is not what the last.
I see the point here.
I'm trying to understand.
This one I have.
Clarification.
Go ahead, pass it.
Just want a clarification. Are you saying that we should adopt something that's not consistent with the law?
No.
Okay, well, what is the other document you're holding up?
You have, it's there.
The information sheet and the
Okay, let me give it to you.
qualification.
I have a whole
I have
question.
the information.
I had the staff get you this copy.
So the other one is what the qualifications.
Yeah.
What I'm saying is that this is what been using.
Okay. And
Right.
you're saying it's wrong.
And it's not fully the
Attorney
information.
General is saying this one.
It's not consistent with the Attorney General said the last said. The Attorney General said that to be to a public office, that is what the revised organic saying. And that questionnaire that we had figured out before left out the correct language in reference to revised agenda. So I'm asking that we adopt the new replacement for the same piece of people where the language is not completely and make reference to the same revised agenda of 1954 that is in the letter.
But what my confusion is this. What I think you're saying is that neither one of these is correct as it stands.
There were two of them that was used before, yes.
Right. So we can't adopt something. What we need to do is, you're suggesting we revise it. There's nothing to adopt.
That portion in the right hand right now is already revised. That's what I thought here.
This has been revised.
Yes, ma'am. If you look at the second page, you see the same language, makes not convicted of felony or crime involving moral turpitude.
Well, I would.
That's the language Mr. Fraser used in his opinion.
Okay, I don't have any problem with
Okay.
that. I do have a problem with the way this is written though, because
Which
it says
one?
no convicted felony or crime involving moral turpitude.
What is
I
it?
mean, in the one that you say has been revised, I think what you want to, I think you might want to make it, flesh it out a little bit, is all I'm suggesting, is that these candidates 1, 4, and 5 cannot be convicted. I mean, it says, it doesn't say shouldn't have a conviction or whatever. It
You
should say no
said-
candidate can be. I mean, it just says no convicted felony or crime involving moral turpitude.
So you're saying that we can change the language, says what?
Well, something to the effect that, no candidate who's been convicted of a felony or a crime involving moral turpitude pursuant to
Can we agree to have that?
Yeah, I'm just saying, yeah, I don't
Okay.
have a problem with the language,
Okay.
I'm just saying I'm having a little bit of a problem with
As
the
written.
shortened way.
So you then would agree and support it if you would make it out clear that no person who has been convicted of a crime of moral turpitude, what you say?
But I also think, if I may, that the AG opinion says more than what this has been revised to, and that you need that. That's why I was suggesting that somebody look at it and make it clearer.
I think he said that
What
it is strict. Yeah?
Did you already get your opinion?
No, I got this is this. is-
Okay.
You also
What he said-
saying after police report on
Yeah.
this form,
Yes,
what
ma'am.
should be added?
That's what should be there.
No, you're
That's-
saying after police report, you are saying something should be added there. Not
It is
bothered
there.
by the first start.
That form that you have in hand right now is what the revised qualification, information sheets are on. Since he said you can't use the questionnaire in its present form, I would dissolve in the military, you get an honorary discharge, you can't ask them if they been involved in social crime.
I realize that you-
So since
when
he
you
said you
started-
can't do that, I said the easiest thing to do to comply what he's saying
Is to add something
is
after police
to
report.
take the same form that we have.
Oh, I
And
see.
you see that one you have in your right hand?
Yes.
If you compare that one in your right hand with what is written on the piece in your back, that Ms. Moore was just speaking about, she's suggesting that right it says, no one convicted of a felony or crime of moral. So all she's saying is change the wording. It says, no one convicted of a felony or crime of moral turpitude pursuant to revised agenda, because that's what he made reference to, and that is a language you can change and agree to change right here. It doesn't matter writing.
No, what I'm saying is that it should be more studied.
Studied? It says studied, you said?
I think I stuttered.
No, I just want to say,
No, but what I'm saying is that, yes, what you said is correct, but beyond what you said, I also said that I thought the committee should take a look at it and flesh this out, because I believe that AG, I'm not quarreling with what you said should be there. I was talking about a little bit of a change in language, but I'm saying that the other qualifications that are listed in the AG's opinion could probably be better written at the bottom of the
Like what?
form as well. I don't know
But
right
you
now,
said-
because I'm not jumping and I don't jump and do things right
I'm
off the
not
top
saying
of my
jumping
head.
is more
Right,
like-
but no, I'm saying I don't. I'm not saying you're saying I do that. What I'm saying is I would not opine as to how it should be changed without sitting down and looking at it. I was suggesting that the committee do it because the committee was doing it before. You have guidance from the AG's opinion.
This is not a
and
committee
it's something
thing,
that-
this is a board issue. It's not a committee, it's a board issue.
Actually, it's not a board issue because it was.
But that's before the board.
But it was the supervisor that did this. The
So you want us to wait to do the bring it to us now?
Well, I mean, that or the committee could help the supervisor do it. I'm just
But
trying to
this is
facilitate.
Mrs. Fox. Mrs. Fox, you understand this piece of paper? I mean, the AG gave us this thing the other day. When it passed them up, Mrs. Mohammed said, we could postpone acting on it until we meet again and review it. You know what that was? Our district will be 300 people. Now today we have something to offer and we need to study it. We're going to study again. It is the AG right there. He said, don't ask these people a question. If you're in charge of these crimes in your outline, the revised Organica is clear. He said, don't ask you've been in the Army or the Navy, the Marine, if you get an honorable discharge, explain where you get the honorable discharge. He said, you can't ask if you voted no place before and where. The Bourgeois code said you can't vote in two places. We cannot map it.
We need to,
So how we need, my motion is to
no,
vote.
we don't make a motion because we don't have anybody from the St. Thomas St. John
What
Boys.
you doing?
I'm going to find them to bring them back in here. That's what
St.
I'm
Thomas
going to do.
St. We just keep walking.
Okay with you.
Yeah, we must.
How these two people are,
There you go.
excuse me, oh, your name is Williams, he's the St. Thomas district people. He telling you,
Nobody
but
here from
say,
St. Thomas St. John District.
Miss Hendricks and, who else? Monsanto.
Yeah.
You need them.
Two of us.
Mr. Wheeler, local Miss Monsanto. Again? This is a competition, we come You need to start any other we want to refer this one. That's what we need to see if they got outside.
Madam Chair,
The motion
Back, excuse me, Member Ross.
I understand the intent of the discussion. The original language allowed someone who was convicted of a felony to run for public office if they was pardoned.
No, sir. It wasn't the revised.
Continue, Member Ross.
Okay, sorry.
If they were pardoned, yeah.
Which language are you speaking about?
The law.
The Revised Organic?
Yeah.
Revised Organic Act of 1952.
Member Ross has. the
Okay,
floor.
sorry.
Let him
The Revised Organic Act says the person cannot, the right to vote and the right to run for public office are two different.
They distinguish them,
Correct.
and not synonymous.
Correct.
Good.
And therefore, someone who is convicted of a felony can run for public office if they were pardoned. No?
It says, read what the things are, read the attorney general right. This is a 10 board right this.
I know what the attorney general.
Could I read it?
What the attorney?
Please.
No, but I want to make sure we understand what time we're talking about.
Well, he could send me the stuff.
I don't have it.
Yeah.
Right here. My concern, no, it's not, it wasn't mine. My concern is basically that you put all of these qualifications, convictions, and it says no person who committed a felony can run, no person who committed a crime of moral felony, crime of moral felony can run, and you put period. If you don't say unless they were pardoned, you say they absolutely can't run for.
They never said that, Mr. Rob.
No,
They
I
said
don't-
pursuant to the 1954 revised Organic Act. If you want us to write the whole thing, we can write it down. But that's what the attorney general said. He didn't write
Well,
it.
but the language pursuant to that act has to do with
Excuse me.
also being pardoned. And I'm just like you were saying that you suffice with that language.
Because they make reference to the 1954 revised Organic Act, I'm sufficed with what the revised Organic Act of 1954 says.
And but this is a document.
First of all, The Revised Organic Act, I don't know to address this, but our code requires people being eligible to vote once they got their sentence or included any period of their incarceration, probation, or parole. But we also, if once you're pardoned, that's the only way you can run for office. Wait a minute. My husband's case, when he tried to run for office, the AG refused to let him run for office because he had not been pardoned. No governor of this territory would pardon him, and they hid behind the fact that the crime that he was convicted of was done in D.C., so the President of the United States would have to pardon him. So as a result, he couldn't hold office, and that's still the case, whether it's him or somebody else. If you're convicted of a felony, if you haven't been pardoned, you can't run for office.
Could he vote?
He can vote, that's two
So
different
then,
things.
is it clear that there's a big distinction between a person's eligibility to vote versus holding public office, whether it was the Virginia's Code, the Revised Organic Act of 1954? The Revised Organic Act says clearly you have to get a pardon. The Virginia's Code speak about serving out your time of probation or parole. You're eligible to vote.
Two different things.
This is what I'm saying. We're talking about this portion that speak about holding elected public office for senator. That's what the paper said. What the paper said? This paper that you have in front of you.
We're not disputing that.
All right, but you said
No, all I'm saying is that the language that's being proposed
where?
in this new document.
What the language? Read the language you're speaking about.
No convicted felon or crime involved, or this is how it's written. No convicted felony, this is why I had a problem with how it's written. No convicted felony or a crime involving moral turpitude pursuant to BIC Revised Organic Act of 1954, Section 6A and B.
So you want?
The language that needs to be in there is unless they were pardoned.
But that's you want to write over piece of language. The whole Revised Organic Act of 1954 encompasses what you just said.
And nobody most people have never looked at the
But
Revised
that is
Organic Act,
what
which is
supervised-
why you give them notice of this here. And
But
that's all
this
we
is
said
why
was
the supervisor of election, this is why the supervisor of election will go over these things because the court send you, the hospital send you, the head department tell you who died, the graveyard will start listing, the law now, Title 8109, apply from A to F. What is the duties of the supervisor of election? If they right there, I'll not put in front of you.
Is she running on?
Hey.
His motion?
Yeah, I make a motion already. I made a motion. My motion, well, the motion was to adopt this document in the place of the old one that was not completed. That was my motion. We must move a second.
I mean, the second.
Someone read this one.
So it's this, what document, you said this document?
The one in your right hand replaces the picture you have in the left hand. And the same thing.
So even though we agree that this could be better written, we're going to try to go to.
We in agreement to be better written. You said you would like to see some more language. And if the majority of us decide and agree that all you need to do is write the word not convicted of a felony or moratorium, pursue the revised act. You want to write in?
No. You didn't just say that. You said adopt this. You didn't say with any changes.
But you said what you said.
But
And I'm saying
you just said your motion. I'm
it's to adopt this as is.
Okay, then that doesn't include the
If you don't want to,
pardon.
but the revised Organic Act is written right in Ms. Moore. You see there? Is what you saying about the revised Organic Act. This word revised Organic Act of 1954 does not say everything you say.
We need the motion written so it can be clear to all the.
No, this is my motion.
Say it again, or have it written.
We see it right there.
I give you a whole folder. No, man, I give you the whole folder in
So who is gonna take that? You see what's so saying? No, I'm asking for the number.
I'm ready to go.
vote.
Hey,
We have
Can we
a
finish?
quorum, move on.
Can I
Member Ross.
ask Member Brian a question? And B, no employee of election is eligible for the Board of Elections?
what did the board just could come from?
No employee of elections.
It's eligible to run for Board of
It
Elections?
is in the code, please look in the code of my question.
Yes.
You mean a lie?
Well, we said
yes.
But that's what it says.
Yes,
I'm
say
saying
yes.
yes, it is there in the paper,
Say
and
yes.
yes, it's there. You asked me something, you're reading.
It's already in the law.
Yeah, read it
Say
in the
yes.
code so you can answer
So yes,
the
this
question.
is game.
We are following the
I don't
law.
want no code. Keep it.
That's how we do, following the law.
Yeah.
That's what the last
But he-
3-minute recess.
Yes, I
one. Keep asking me the last one, I'm not putting in front of you. Then I read the code.
So next time you look at
Follow the law.
the.
These are for me and Jerry. This is for me and my wife. This is for the people that want to be elected from himself.
Understand?
But I tell you, that's foolish to ask me all the time. If you reading it and you ask me that, did you write this?
Time consuming.
I'll show you where the paper got on. It's from my paper I take it from. I show it up here already.
I don't have the paper here.
But for us, I show it up paper already.
I do.
So we have our,
Hey, you step up.
That's the should be the same, right?
No, that's not the point.
So respect the movement or what?
The point is that you don't have your vote and you don't vote. You don't vote, explain it.
give Member Brian the motion form so he can write his motion so he
I
can.
correct it now? I went motion so that
I want you to,
no, this
there was something else you were saying.
Minister next thing.
Because I'm not clear on the motion.
My motion was
You have to
that.
come in and wait till
This is over.
Yes, sir. Because we already have an old farm like that already.
Yes.
Those two pieces there, replace the old two pieces.
Okay, so,
Yes, sir.
what's the difference between this one?
Because the one portion you have your right hand, you only have one felon. The other one have felony or a crime involving moral turpitude pursuant to the revised Atlantic Act of 1954. That's what of that one you have in your left hand. You see it? And the old form that you have there, then in front of that piece of paper, sir. You got it? And the old farm that you have, look like this now, this is the old farm that is still having the board of election right now.
The top page.
Yes, sir. It says to the bottom, candidates are required to attach a copy of police report. That's the only two change they have in the farm.
We're not that.
In recess, skip the top.
Oh, okay, I'm sorry. Remember Brian, he said that no employee of elections is eligible to run for the board. He said that was in the code, can you?
It is written, I don't have my code.
Well, the reason I'm asking is because for everything else, you can step down from your position. Are you saying that the code says if you're a member of the...
It has a requirement that you take leave of absence. That's what it says.
But it doesn't, okay, which is why I asked the question. It doesn't say that here. It says it for the other ones. Like B, if you look on your revised thing, B doesn't say you can take leave. C does. So that's why I was asking. I don't know of anything in the code that totally prohibits somebody who works for elections to run for the Board of Elections.
Is that the same question that was raised when Mr. Mushota was trying to get a position as a supervisor of election? All I remember
That's
that
the
no I
reverse of it. That's the reverse of it.
But
That's
still,
a
let me
totally
finish. And again too, is it also when would members took leave or didn't take leave to seek other office? Then you have a provision where you have employee didn't seek position. The law, I didn't admit it there. It says, that's what it says in the Voisinance Code. On whatever the title is, title 18 in the chapter. Eligible employees have exemptions to the Board of Education, election, and make provisions for what they can do.
Right, but under the Board of Education, you have the right to take leave when five.
Because that's what the Virginia's code provides.
Okay, my question was, it doesn't, are you saying that it does not provide that for an employee of elections? Mr. Bashilta has never been an employee.
I don't pass here already.
So, well, what you're saying has no effect on this.
What I'm trying to get you to understand is that it's appropriate and convenient when I want to know the thing and ask questions.
You're making an analogy that.
But that's what you're doing.
No, you did. You said something about Bashilta, which has nothing to do with
I will show you examples where people have to do
Are we
something.
back on the agenda?
Yeah, we're ready for it to come.
My question remains, shouldn't we have language there that says unless they take leave, the same way you have for the.
Do you want to make a recommendation we add it and then make a motion to amend it?
Unless you're saying, my question was to you, you said you don't know where it is.
I try to look at the code first. So you ask unless you say something. Are you want or are you willing to change and say add this that they take it? You want to add that amendment?
Well, there's more than that I want to ask.
Well, then how do you want to add that?
I can't do stuff like this for the moment.
What are you going to do? Eat and tie back to me?
I'm going to talk back to you, come over and do lots of things to you, but it's not my preference right now.
Well, I
And
hope you will preference not to do anything.
What I would prefer to do with something this important is to take the opportunity to look at it.
I hope
thoroughly and say,
but you say you want to take the opportunity from the last bill, need to review that same thing.
No, this was never.
I showed this around a piece of paper.
Brian, that's the form, Ms.
I was not.
What's this one?
This one, you
I
can
haven't,
send
you just said was revised, but it's the first
This
time
is
I'm
one piece of
seeing it.
paper I had the last time I shoot up on you. You guys
First of all, I wasn't at the correct meeting.
That's good. This should be over there.
I never saw this.
Did you see that? Did you see the old one?
I saw the old one.
So tell me what's all of it. What is
I
that?
said that I am not.
What is that old one that is so
I'm not
different
saying
than the first
anything
one?
else other than this. I am
It's
not
your
concerned to deal with this. With some thought.
We're gonna go back into,
Where's the copy of the
I just passed, that's something written on it.
I'm looking for specifically say one.
Now we have no quorum. Hold on a second.
We have a quorum unless it's.
Right.
The people walk out of the room, if they're not gone, we still have a quorum.
In here, we didn't have.
What about the other? It's still
And here, the meeting is continuing unless you have somebody ask for a
Correct.
quorum.
And I wasn't done.
Okay, next time I go, because I don't know, so now we're coming to meetings. There was a motion, Member Brown.
I wrote it. What was the motion? I wrote it.
I swear. You know something, Mr. Williams, in all due respect to you. You understand? I am over 70 years old, and I can't play the stupidity thing that get me with adults. You give them a piece of paper. You see what Ruffy will tell what illiteracy can't comprehend? You see when you have to do that in the radio, because we hear that at least at 12th grade diploma and degrees. And we absolutely check and check.
We're back on the record. There was a motion, Member Brian, that you made.
I made the motion.
And who second? Repeat your motion, and Member Molinar second. Please repeat the motion.
The motion is for us to adopt this new format in compliance with the Attorney General and replace it the old one that we used to use because the language that was complete according to the revised and that Mr. Fraser said in his letter. The net document is clear, referencing the revised Agreement of 1954 that encompasses all the questions they're asking me. You couldn't write out the whole thing.
Member Moore, do you have that? Well, give Member Brian a motion
It's
forward.
there.
And let him get down on that. Excuse
What he's
me.
saying is to adopt a new candidate information sheet as written. I can write that. But
If you
all
wanted
of
to
the
say
stuff
that.
in
But that's all I said.
Well, I wrote to adopt this.
It's not.
All right. It's been seconded by Member Molinar. Roll call.
Mr. Schulten, absent. Mr. Daniels, absent. Ms. Georges, absent. Ms. Lydia Hendricks.
No.
Arturo Watlington, absent. Ms. Alicia Wells.
No.
Ms. William Eduardo, excuse me.
I'm voting.
Not voting, saying Mr. Delbert Ryan.
Yeah.
Lisa Moorhead, no. Mr. Mullenmar, Mr. Rupert Ross.
No.
Glenn Webster, is he gone?
Going in and
There was that.
Absent. Mr. Raymond Williams.
abstain.
Three yes, 4 no, 2 abstentions.
We'll ask the audience to please keep it down or take your conversation up the door. What's the number there on the vote?
3 yes, 4 no, 2 abstentions.
Also, it's low. Next part of our agenda. Our next item on the agenda.
Good, Monsieur Cool. Monsieur Cool.
The payment. Scott McShane,
Number 8.
McShane, payment date.
One,
On the agenda.
You do number 8, Madam Chair?
Yes, we
I'd like to address that.
All right, number
I asked to be placed on the agenda. I believe every board member received a an envelope with some information in it concerning the chronology of events leading up to the current status of non-payment of Scott.
Excuse me, I did not receive.
When are we supposed to get those envelopes?
They were handed out.
They were handed out today by the, one of my assistants.
No. I haven't got.
Tricia had been out earlier, I don't know why, but
I would give the chair mine. Yes, the letter goes to President Malone. I apologize, I see that you get one.
I'll check on it.
Okay. Let me just say how we got where we are. The legislature passed an authorization to pay Attorney Malone, Attorney Scott, the governor, Scott McShane. The governor vetoed it, and the grounds that one, as far as I understand, one, the board has already had authorization to use prior year funds, and that the money should come out of the board's existing appropriation. How did we get to this point? We went to the legislature because when we were constructing the the current year fiscal budget, in response to a question from me, the advisor from OMB basically said that money was spent in 2013 to pay the prior year obligation. We needed to get authorization from the legislature. Basically, the legislature acted based on the correspondence we have before you. It's a letter addressed to the Senate President Michael Malone. I'm not going to read it, but I'm going to take you, since we have a significant number of new members of the board, take you through the steps that occurred. In February the 7th, 2012, action for declaratory judgment, preliminary and permanent injunction, injunctive relief was filed against the supervisor, myself in official capacity as chairman of the St. Croix Board of Elections and the St. Croix Board of Elections. And for those of you who have a packet, that's attachment number 1. On March the 21st, 2012, the plaintiffs in case amended the complaint, which is attachment number 2. On April the 16th, 2012, the Department of Justice filed notice of withdrawal of counsel for approve the ground drainage and St. Croix District Board of Election members. And that's attachment number 3. On April the 25th, 2012, consistent with current Ordinal Code Title 18, Section 51, as amended, as passed, the Virgin Islands Joint Board of Election voted to authorize the hiring of an independent counsel. On April 27th, the Virgin Islands District Court granted the Virgin Islands the Justice Department motion to withdraw as counsel. On May the 2nd, the St. Croix District Board executed the Virgin Islands Joint Board of Election authorization to hire counsel and voted to reallocate its travel funds for attorney fees and other related costs. On May 2nd, the chairman of the St. Croix District Board, myself, executed a letter of engagement hiring attorney Scott McChain to serve as counsel for the board. Authorizations, attachment 7 addresses the payments that were made to attorney Scott McChain as authorized by the St. Croix District Board, and attachment 8 is an invoice detailing outstanding obligations. As it stands right now, the attorney has not yet been
Have the
paid.
excuse of, I have to leave. Have the excuse.
Quorum come. Quorum come.
I did that.
Yes, you.
So Larry Schulter, Mr. Harry Daniel is absent, Ms. Claudette George is absent, Ms. Lydia Hendricks. Ms. Wilma Marshall Santo, absent to herself. Ms. Arturo Watlington, absent. Felicia Wells, present. Luann Belardo Daniel. Albert Bryan. Lisa Moorhead, Mr. Lauren Molinar. Rupert Ross.
Here.
John Webster. Mr. Raymond Williams. 7 St. Croix members and 2 St. Thomas members.
Motion to withdraw without a quorum.
Second.
I'm sending you a cover letter.
This is yours. I didn't get it though.
Give it a cover letter. And I will see, the supervisor will see that additional copies are made. I don't know why you didn't get it.
Just as we were calling last year, the same was calling because when I report from last year, the principal the cousin, Jimmy, because Jimmy was trying to take president. So what happened to I think that was last week. I how do you not go smarter than you need at least 3 cents to either side. It is, I put the little hard and tell me he got to the master report. See what you know? He get his cousin, Jimmy, to make the shine alone. So after the floor, they come up with top of the budget, the class, and say, hey, can we vote for that? I can't know smart but you don't have I speak to these people.
Yeah, but you're lying. It was already a joint board.
Where?
It's a joint board.
I tell I cannot spend money without the giant board approving it.
And the joint board approved it.
Approved the authorization to hire. I will keep a meeting, I didn't have a meeting.
No.
Show me a trustee for a meeting.
What they approved was us using our travel fund.
No. You can't find more stuff. I cannot trust you. You can't find that. I have a trust. I can't trust you. I have a trust you. Take the report. he doesn't see the brand new. He never gives a report. After the fact, he bringing this to the board. So he tell it to us, he give to Jimmy because we try to tell him not like that.
Let's go.
We can have the center and then put override. Put them override. Type me also put override.
Polling.